Good afternoon. We are coming to you today with 4 different perspectives about documentation. We are from 4 different professions. We have an estate planning attorney, a financial planner, a CPA, and a realtor. We all require paperwork and documentation to take care of our clients. And we're going to give you 4 different perspectives on how documentation can either help you or potentially cause you damage. I'm going to go ahead and get started, first of all, from a real estate perspective. Of course, we need to have contracts for homes to be bought or sold. And with our contracts, many times signatures are electronic. And with electronic signatures, what I find clients saying is that, oh, well, there's certain things that are just boilerplate, and they pick up their phone and they just click, 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 click through the document. Well, whether something is boilerplate on the contract or it's a fill in the blank, when you're signing that document, you are signing a legally binding contract. And so it's important for you to know what is in the contract. In California, which is where we are all located, we use forms from the California Association of Realtors. And the primary form for a purchase is the purchase agreement, and the primary form for a listing is a listing agreement. In the case of a purchase, that's just one of many forms that are used collectively to provide protection for the people that we represent. For example, we have over 100 forms in our forms library. And by choosing the appropriate documents to go along with the residential purchase agreement, if it's for a home, or with the listing agreement, if it's to list a home for sale, that's what makes the package unique and special. And so it's important for my clients to understand what is in those supporting documents, not just the main document. And the third point that I'd like to share is that when you are dealing with a contract, the person who drafted the document has a bias, and it generally leans toward that bias. So in the case of the California contracts from the California Association of Realtors, they have a heavy bias towards protecting the buyer, the consumer. It's different in commercial real estate, but in residential real estate, the forms really offer lots of protection for a home buyer and not as many protections for a home seller. So it is important to be aware of all 3 of those points as it relates to residential real estate. Next, we are going to hear from Tara Van Zandt, CPA, and she's going to talk about documentation as it relates to her side of the business. Tara?
Thank you, Cheryl. So with taxes, this time of year especially, you're getting all your documents ready. You know, you may have those W-2s or those 1099s or your expenses written down on your financial statements. But what you need most of all is backup for those expenses and backup for those charitable contributions. And all of that stuff, you're not going to say to your CPA or your tax preparer, you're going to hold on to that. And what I see more often than not is people don't always have that organized, or they don't always have what they need. So the issue with that is if the IRS comes in and you don't have what they call substantiation or adequate documentation, they will basically say you can't take that deduction. And in some cases, they may also say you are now subject to penalties because you didn't adequately document what you needed to. And now you may be subject to fraud penalties. So that's, so that can be an issue. And so basically, you need to make sure that you have those in organized and ready to go. And basically, some of those things are, if you're a business owner, a lot of times that's your credit card receipts, but that's not even just enough. It needs to also be basically invoices or something showing the place, the time, what it was for, that it made sense. For meals and entertainment, for instance, you need to have a receipt showing, and then you can just even write on the back of that showing who you met with, what the purpose of the expense was, when it was, and that would be enough substantiation for the IRS. But basically that's what you need to have. Mileage logs are a good idea. Charitable contributions, you need to have something from the nonprofit showing that you paid that money. If it's something you gave that isn't a cash donation, then you need to have something showing what it was and why you think it was worth that. Sometimes even pictures showing that it was in good shape is a good idea. So those are some things to keep in mind as you're getting everything together. How important it is to have the backup too, and to have that included. And then I think a lot of times the question people have most of all is, how long should I hold on to that information? The best practice is 7 years. What the IRS requires is 3, or the state of California requires 4. 7 years is usually the best practice, because if you had something else happen, you may be subject to a 6-year period. So usually 7 years kind of covers you. Tax returns, you want to, believe it or not, you need to hold on to those forever. And this goes for estate and trusts as well, and any individual information. Gift tax returns you would hold on to forever. And then, I think the last thing I kind of documentation wise I wanted to talk about was just be wary of the online provider that you can prepare your own tax return on. Just make sure you know what you're putting in, understand what you're doing, understand what you're filling out and why you're filling it out. If you have a W-2, it's usually pretty simple, and you probably can't have too many problems there. But anything more than that, and you can sometimes come into issues where you think your tax return is good and it's really not.
Okay, so it sounds like documentation, and we all know because we love tax time, that the documentation is super important, but the DIYers can get into some challenges sometimes because they think their paperwork is correct and it is not. Is that right?
Right, yeah. Well, and so it's a good idea to talk to your CPA about what kind of documentation you need for whatever you're looking at, whatever expense, whatever you're looking to deduct, and they'll be able to tell you, and how long to hold on to things, and what you should do, basically.
Fantastic. So I didn't say it at the beginning, but of course at the end of the presentation, there will be the disclaimer that we are not giving specific tax, legal, real estate, or financial planning advice in this presentation. This is just a calm little chat between 4 financial professionals who support the same client audience. And so we're going to hear from somebody new today. We have Eva Carnival, and if I'm saying that wrong, super sorry, but I'll get it right eventually. Anyway, Eva is a financial planner, and so she's going to give the perspective from the financial planning world. Eva?
Thank you, Cheryl, and you were very close, so I give you a lot of credit.
Okay.
So, when setting up a financial plan, financial advisors will typically outline a client's goals and then work through different ways to achieve them. So what we do is, we start with a conversation about what it is that the client wants to accomplish and the timeline before they would need access to those funds. And then we'll make specific recommendations for that individual. And those recommendations might be, investment strategies or specific investments that suit their goals, but it could also be different savings vehicles, like an IRA or maybe a 529 college savings plan, or contributing to your 401k at work, different things like that. And so because the job of a financial advisor isn't static and it's constantly evolving with, if your life changes or different things come up, we're constantly evolving that strategy to make sure you can be where you want to be when you want to be there. So we don't have specific documents like the other ladies here might have, but we do recommend that our clients always work with CPAs and estate planners to make sure that everything's accounted for and there's checks and balances. At the end of the day, they're the framework where any sort of account would be documented in terms of, a legal standpoint. But I do have two items that I want to highlight of key importance. The first would be something called an IPS, and that's an investment policy statement. That's what that stands for. And that's just something between you and your financial advisor that outlines what you're comfortable doing in your investment world. Where does your investment portfolio lie? So that IPS is something that you should update every year with your financial advisor, just to make sure that you're on the same page with your risk tolerance, which just means how comfortable you are with the market going up and down, and just making sure that you and your advisor are on the same page and you're both comfortable with where your portfolio sits. And the other one I want to mention is beneficiary designations. And I'm sure Sujan will get into this as well, but it's definitely a really important part of your financial plan. Oftentimes, too many times, more times than I'd like to admit, we see that people forget. They set up a 401k plan at work when they're 21, and then they pass away and they never updated it from their girlfriend at the time. And so unfortunately, those beneficiary designations on all of your accounts will override any real life situation you might have going on. So just keep in mind, every year, when you file your taxes, check in on your beneficiaries, make sure they're the right person, make sure that they're up to date, because that's a really a key thing that might get you in some trouble when you pass. Might get your family in a little trouble. It might be a sticky situation. So those are just my two keys.
Well, fantastic. Thank you so much for bringing that insight and perspective. And the point that you made is certainly very strong, and it affects all of us. And that is, it's pretty upsetting for the wife whose husband has passed away to find out that part of his pension is going to the first wife. That is not something that can be changed. That is very, very unpleasant. So pay attention to your beneficiaries. I'm so glad that you brought up that point specifically. And so the three people that you've heard from so far, we deal with our clients while they're still alive. And the repercussions of what happens generally happens while they're still alive. We're going to hear from Sujan Kim now, estate planning attorney, who, of course, by the time the documentation is needed, it means that they are no longer alive. And so her perspective is going to be interesting to hear. Sujan?
Yes, thank you, Cheryl. Just like you and Ava had pointed out, estate planning documents, you really don't find out whether they're, good, bad, or otherwise until after the person has either passed or even incapacitated. So it's not a position where they can actually redo or, fix the document or make it valid. It's already done. So the court will just have to follow the letters of that document. And where I see a lot of people get into or face some challenges is when they try to do it alone, when they try to do the DIY or use online templates. Like Tara had mentioned, you have to know what you're putting in. Like if you don't know, you don't know. If you don't know that that's the wrong document, then you just don't know that that's the wrong document. And with being in California, I think it's crucial that you speak with an advisor, with an attorney, with someone that can guide you, because California is very specific in the language that they use and the documents that they use. For example, I had a client who called me, we had a trust done a long time ago, but so much has changed. I want to update it. I said, okay, well, send me the document that you have. And what he had was a living will, which is not a document commonly used in California. What he had actually created was an advanced healthcare directive, a medical directive for someone to step in if he's unable to make medical decisions. It was not a trust. But because we, typically call our trust living trust, he saw living will. So he thought, okay, that must be, pretty much the same thing. It's probably going to avoid probate for my family. But in fact, it didn't. And on top of that, on the template that he had found, it required 3 witnesses, so 3 disinterested witnesses, and he couldn't find 3 at the same time. So he had never gotten it witnessed. So that's the other thing is, one, if you're trying to look for documents on your own, there's a chance that you might not find the right documents. And two, even if you find those documents, there's a chance that you might not ever get it executed. It's never valid. So if he lived for the past 20 years thinking that he had a trust and that his homes would not pass through probate. Well, good thing that he actually thought about it. And when I brought it up to him, he just red in the face because he had no idea that there would be such a huge difference between a living will and a living trust. But I don't expect any person out there that's not an attorney practicing estate planning to know that there are terms just thrown around, used interchangeably, but they mean vastly different things. So what would have happened is that his estate would have gone through probate. So probate is the court supervised process where the court determines what kind of assets the estate has and then determines who's the rightful heir to benefit or be the beneficiary. And then they decide how to distribute. So for one, probate is a really long process. In light of the pandemic, it's just even longer for you to get a hearing. It's at least 5-6 months out. And that's just to start the probate process. And even when you're going through probate, there's a lot of documentation in that too. And like I said before, if you don't know, then you don't know. So there are some people who are held up in probate court for a very long time because they just can't figure out what documents they need to complete to get it started, what documentation the judge is referring to. It's basically you fighting a legal case on why you should be the person to petition to start this process and who should take and how much there is. You're asking the court to believe you, but you can't figure out any of the forms or the documents to support it. So the court can't just, honor what you're saying. You have to put it in writing. California is a very, very statute heavy state. We are very specific with very specific requirements, and the law is unkind to those who just don't know it or don't figure it out. So estate planning, I would, even if you DIY, even if you think you know it, just ask someone, ask an attorney to just review what you think you have, and then just make sure that it is indeed what you wanted.
Well, fantastic, Sujin. As you've heard from each of us with the clients that we serve, there's a lot on the line when documentation is not properly prepared. In the case of your taxes, you might have penalties, and Tara even used the F word, potential fraud. Nobody wants to deal with that. With a real estate transaction, there could be transactions unraveled. You could leave money on the table. And with the estate planning, that ex-wife might be getting money that should rightly be coming to someone else, just as one example. And unfortunately, as Sujin pointed out, you don't find out if the documents are in order many times until someone has already passed. And at that point, the die is cast. It's going to be whatever it is, whether people like it or not. So this is our financial chat for this month. Documentation, not a sexy topic, and yet it's a critical topic for you to be on top of if you have assets. Next month, we will have a different topic, and we'll keep you posted on that. Bye-bye now. We're signing off.